In this module, we're going to learn about alternative dispute resolutions. Suppose that you are a business person or a consumer and you have a problem. And there's several ways you can get this problem resolved. First, you can always get involved in negotiation. That means the parties talking to each other. If the talking doesn't work, you can always file a lawsuit. Taking your case to court is called litigation. If that doesn't work, you can get involved in resolving the dispute by arbitration. And if you would like, you also have the choice to do mediation. Let's make sure that we understand the difference between all four of these words. First of all, negotiations can go on at any time. Before the jury comes back with a verdict, you can negotiate a resolution that's appropriate. Litigation just means taking a case to court. Arbitration, you put on evidence. And the decision is made not by speeches, but by the evidence. But the really important part about arbitration is that it's binding. This word binding means that neither party can take their case to the Court of Appeals. It means that both parties have to live with the result. And what guarantees the fact that people will be bound to the decision? Well, the arbiter who makes the decision asks both sides to sign a document that states they give up their rights to appeal, and no matter what happens, they'll live with the results. Mediation is important because it is voluntary, and in fact, mediation only works about 77% of the time because people, if they don't like what's going on, they can get up and walk out. Mediation is important when the parties have to live with the final result. For instance, let's assume that the adults have a challenge with the visitation and child support. Well, both of these parents know their children a lot better than anybody else. So when they sit down and talk about the realities of a limited amount of money, limited amount of time, they can fashion with themselves, listening to each other, on a result that is appropriate. Again, with mediation, either one can get up and walk out. But once they reach a decision, then that decision is put into writing, and that decision then becomes binding on both parties. Mediation is extremely important for us, and the mediator is somebody who is professionally trained to resolve the disputes, professionally trained to get to people to listen to each other. I am a certified mediator, and I enjoy doing mediation. My mediation rate is about 98% because I listen to both sides, I let them try to work things out, and then as a trial attorney, I sat down and said, folks, here's what's going to happen if you stop listening to each other. And once they take a look at the realities, then some appropriate decisions are made. But right now, I want you to take a look at a video about mediation that occurred in district court.
Gentlemen, at this time we're going to call the calendar of cases set for the courtroom at this time, and we would ask that you respond in one of the following ways. If you have an attorney, answer with your attorney's name. If you need to continue your case, answer motion. If you would like to speak with me, the assistant district attorney, before you make a decision as to what you're going to do with your case today, then answer open. If you are not going to answer in one of those ways, you need to answer with your plea, and that will be either guilty or not guilty. If you're a witness or a victim in a matter, I will not call your name, but the name of the person charged. When you hear that person's name, please answer witness present. Also, too, we ask that if you are interested in mediating your case today, when you hear your name or the name of the person charged, please respond with mediation, and that will be noted accordingly. Vicky Bunn. Ellen, not guilty.
All I want is for him to leave me alone.
Stacy Jackson, Charles Lasseter, Natasha Lucky, Laura Patterson, Willie Winters. That concludes the first calendar call. There will be a note within an hour. If you would, please remain seated and quiet with your second calendar call to check in if you missed your first calendar call. If you were here for the entire calendar call and did not hear your name call, then please go to room 102 and ask the clerk there about where your case is set. You should not sit here at this time. Thank you.
Thank you, Madam DA. Mediation has been recognized as a tool, and there is a significant backlog of cases, of course, which tends to have this courtroom to have situations where not all cases may be reached. So you can have a more immediate resolution of your matter if you decide to go to mediation with your matter and have a successful outcome related to that. Similarly, it will be your last opportunity to have any input in the resolution of your matter, because in fact, if you cannot mediate the matter, then that means that the matter will be for the court to resolve, and the court will be bound by the evidence as well as what the outcomes must be as dictated by the legislature in terms of the authorized legal outcomes. So you may have more input and come to whatever resolution you may feel is appropriate for your circumstances between and among those parties involved specifically. But if you cannot do that, then it will be to the court to get an outcome that the law would dictate should occur. So again, contemplate mediation is a valuable tool to relieve court docket congestion and also allow parties to have a reasonable opportunity to have significant input into the outcomes of their respective cases. Please consider mediation. Thank you. Thank you.
Well, this is different. Maybe it's a good idea. How much did you say it was? I just want to get on with it. All I want is for him to leave me alone. If he could just mind his own business. If I could only talk to him, he'd understand. Okay, I'm willing to give it a try. Really? Yeah, let's do it.
Sean Williams.
Yes.
If you come through the screen, David, take the note table. So the line of charge against you is the North Point Council, your own lawyer or represent yourself.
I'll represent myself.
Come over to see the clerk of time way before me to represent yourself by the order. Is Billy Jeffries here? Billy Jeffries.
Mr. Watson, Mr. Potts, come forward, please. Mr. Watson, my name is Ryan Campbell. Mr. Potts, I'm Ryan Campbell. Come on, folks. Gentlemen, have a seat, please. Fellas, once again, my name is Ryan Campbell, and I'm here to explore the possibilities of mediation of your situation. Before we begin the mediation, I'd like to talk with you about some of the basic rules that we're going to follow. First of all, I want to listen to each one of you, and each one of you will have an opportunity to speak. But I ask that you speak without interrupting the other party. After we've had a chance to talk each individually, then we might, the three of us, discuss something and see what kind of resolution might be available. Also, before we begin mediation, there are three words that start with the letter C that I want to share with you. First and foremost is the letter C standing for confidence. I cannot tell any of your secrets, anything that we talk about,
will stay right in this room. I cannot go out in the courtroom. I cannot be subpoenaed by either one of you as a witness. So what we're talking about stays right here. Everything is in absolute confidence. Second of all, the letter C stands for court. I'm not the judge. I'm not here to say one person is good, one person is bad, that you're right and that you're wrong. We're here, the three of us, to see if there is something we can do to reach a appropriate resolution. Of course, a resolution where the terms are written down. The third C stands for the word cost. As you know, in this particular courtroom, there is a cost of court for criminal matters that has been mandated by the state legislature. In lieu of paying that money, you can save $40 in the cost of mediation, which is $60. Fellas, do you have any problem with the cost of court? Do you have any questions so far about the basic procedure of mediation? If not appearing, Mr. Watson, I'm going to ask you both to fill out a form, if you would please print your name, your address, your telephone number, and make it in large printing. I've got old eyes, I've got to be able to see. Mr. Thomas, this is permission to mediate. Would you please also sign your name and print your name? And this, again, summarizes what we've talked about. As soon as we've done this paperwork, we can go ahead and begin with the process of mediation. And would you print your name, Mr. Pappas, please? All right, good. And we'll just share pieces of paper. You both print, sign your name, fill out the information, please. Okay. That's fine. Now, let's begin. I'm going to ask Mr. Pappas, what brought us to court today?
Well,
All righty, you saw Mr. Pappas and Mr. Watson have their dispute resolved by mediation. Did it work? Well, as a matter of fact, both fellas got a chance to say what they needed to say, get the venom out of their system, get the emotion expressed, and then they got realistic and they resolved the problem so that it was at the best for both sides. And that's the value of mediation. As you saw this tape, you saw that both of the people agreed to the mediation at the beginning. At the end of the time, I hand-wrote a single document, had them both sign it, photocopied, and everybody got a written record of the agreement that they reached through mediation.